Welcome to the courtroom, where one man's lie just might cost him everything. This is the bond violation hearing of Mr. Johnson, who claims he drank O'Dallas, a non-alcoholic beer. But when the judge starts calculating his back levels, that story crumbles faster than his credibility. Today's case isn't just about alcohol, it's about trust, timing, and whether you can talk your way out of a corner you lied yourself into. Stick around, because by the end of this video, you'll see a judge deliver one of the most logical takedowns we've ever seen. Hit subscribe if you love real courtroom drama. This one's wild.
Good morning, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Judicial Banks occupant.
Pardon?
Judicial Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes...
Right, here, listen closely. This is where Mr. Johnson admits the truth. I was drinking beer. After playing the O'Dallas card for way too long, he finally folds. But the damage is done. Legally, this is a massive problem. Bond violations, break the agreement keeping you out of jail and lying about it. That's practically asking for a revocation. His lawyer tries to soften it, but the judge isn't buying the timeline or the excuses. He's not just under scrutiny for what he drank, but how long he tried to mislead the court. Question for UF. Someone lies once, can they be trusted again? Drop your take below.
It is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of...
Boom, there it is. The judge just did the math, and it blows Johnson's story to pieces. For him to have that back from O'Dallas, he'd have to chug 25 bottles in an hour and not use the restroom once. Let's be honest, when your excuse is physically impossible, the judge has every reason to doubt everything else. This is legal humiliation in real time, and the judge is using logic as a scalpel. This isn't about alcohol, it's about deception. Would you keep him out on bond after that kind of lie? Let us know in the comments.
From the entry of this order, or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan.
Now the defense pivots. Johnson's a business owner, a dad, a good man under pressure. But the judge isn't moved. And here's why she says it clearly. He couldn't even be honest about why he wasn't honest. That line right there. That's the turning point. In court, character matters, but not without credibility. If you lie while begging for leniency, the court questions your moral compass, not your stress level. This is where sympathy meets the wall of the law. His personal life sway you, or does that lie override everything?
Who, as far as I know, actually exists, but I don't have any evidence to that effect. Has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
Johnson's got a whole support squad behind him, his wife, his pastor, his church. It's the picture of redemption. But here's the real question. Does courtroom forgiveness come from the people you bring or the truth you tell? The judge is clearly wrestling with it. She wants to believe he can change, but she also can't ignore that he manipulated the truth. This is where the emotional stakes rise. It's not just about what he did. It's about whether he's truly different. Now, Dot, would you give him another shot? Hit the comments.
All right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Right.
you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I
you
have
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
is
need
supposed-
to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow.
This is brutal honesty from the bench. He looks stupid, but he's not. Translation: the court isn't fooled. The judge walks through every version of Johnson's story. O'Dell-esque beers. 4 beers and calls it what it is. Lie. And when judges feel insulted, things get serious. This isn't just about punishment, it's about respect for the process. Here's a legal truth. Once you lie to the court, you better have a miracle in your pocketbook. A seriously good reason. Has Johnson already burned his last bridge?
You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court. So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and counterclaim to what?
to their complaint for eviction.
The prosecutor steps in, and she's not here to play. Johnson, she says, has shown zero insight into how dangerous this could be. He's carrying weapons and drinking while on bond. That's a recipe for tragedy. From a legal standpoint, this is when the court has to weigh potential against public safety. Should it gamble on rehab or act to prevent disaster? This is the justice system's tightrope walk-hand. Everyone's watching. Do you think the court should risk one more chance?
Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order.
And here's the decision. Mr. Johnson walks for now. The judge issues a strict personal recognizance bond with a SCRAM tether, basically 24/7 alcohol monitoring. He's got 10 days to enter treatment tour. She's issuing a warrant. That's what we call a last chance clause. The court didn't jail him, but it's watching every move he makes. So, was justice served? Or was this judge too soft on a repeat liar? Let us know in the comments. And don't forget, if you love courtroom drama, hit that like button, share with your friends, and subscribe. This is real law, real emotion, and real stakes. You won't want to miss what happens next.
Thank you.
Thank you,
Okay.
Your Honor.
Thank you.
I know, you didn't write anything.
We'll await. I did.
Oh,
No.
no, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you, Your Honor.
Court's